All right, the next case will be Genuinely Loving Childcare versus Bray Mariner Conway Crossings.
Good afternoon, Your Honors. James Markle for Gentle Loving, and the gentleman with whom I practice law, Shane Bowdy, also. And I'd like to request 20 minutes for rebuttal for him, and I may stop before 10.
But you only have 20 total.
I'm sorry, 10. I'm sorry.
Okay.
You know, I am getting
That's
older.
one way to try to get more than 20
I'm just getting older.
minutes.
You know, the first thing in my mind comes out. I'm sorry.
All right, you may proceed,
All right.
sir.
This case, to categorize it, is a de novo review of the grant of a summary judgment in a specific amount of $200,000 against the defendants, including 2 individual defendants under a written guarantee agreement. And using my own form of mnemonics, we have categorized this as the all rights appeal. And we'll explain what all's right, not all rights, but all's right. 1, the appeal was filed on time. Number 2, we're trying to overturn the grant of a summary judgment. Number 3, the summary judgment was granted without any evidentiary hearing, none. Number 4, the affidavit in support of the summary judgment by the landlord's representative was not based on personal knowledge, but rather, I am competent to testify. And number 4, and most important, which is both law and facts, is that the affirmative defenses were never countered by pleading, but really in 2 memoranda by the landlord. So they were never countered in pleading, and they were never really opposed. What's most important is that the trial court did in no manner address the affirmative defenses. And what happened here is a very simple plan. We can call it bureaucratic bungling or whatever we want. But our clients worked as hard as they could once they determined that the location in this shopping center was where they wanted their child care. So the first thing that they were required to do was to have a play space. And when they looked at the space, it looked as if it might be a little difficult to have an outdoor play space. And so they talked with DCF, and DCF said, well, if, and this is in the affidavit of ROCCI, not the quotation, but if you get an urban designation, then you can have an indoor play space. They did that, first of all, going to the zoning officials for the city of Orlando and Orange County, and then getting the designation from the zoning standpoint from the department, the DCF. They signed the lease at that point, knowing that they were going to get a child care facility there. And this, to me, is the whole thing. As we learned in law school, I never did understand it, but the pith of the lease is right there. The pith, I love the word, never did understand it. Okay, in the lease drawn by the landlord, and almost half of this appeal is repeating this 58-page lease, which clearly, if it wasn't a Philadelphia lawyer, it was pretty close. The demised premises, this is on page 16, the first time that the lease was put in the record. Shall operate the demised premises solely for the purpose of the operation of a child day care center for children. In addition, there was some language about no more than 25 children from 6 weeks through 5 years of age shall be permitted within the devised premises, and so on. This was the landlord's only use for a child daycare center.
It could, even without the outdoor playground though, the law permits a drop-in daycare, correct?
I'm sorry, Your
Law
Honor.
permits a drop-in daycare center, correct? I mean, you don't, without the outdoor play area.
I don't know if that's the category. I honestly can't answer that question, and I went through the record again as I did in writing the brief and participating in the reply brief. I'm sorry to say I can't answer that.
Okay.
If that's a category, I'm unaware of it. The point was to have a daycare center at this location and to have indoor play space, which was allowed if you get urban. All of that was done. The lease was signed. The lease says only for a daycare center.
Is it-
No, that didn't answer your question. Yes,
Is
Your
it
Honor.
your position that that language that you read means that the landlord is going to assume any risk of them not being able to operate as a child care center there?
I'm assuming this, that in addition to trying to support their motion for summary judgment with an improper affidavit saying I'm competent to do this but no personal knowledge, the evidence, if we were allowed to have an evidentiary hearing, would show that indeed possibly they could have allowed it. It just didn't seem proper at the time because Publix was nearby and didn't want it. The point is, I'm not arguing about what would be presented. I'm arguing we weren't allowed to present anything. And I was at the hearing, which doesn't, my statement does appear. I said, Judge, I'm sorry. We had a license. There's kind of an argument among the attorneys as to the use of my word revoked. Well,
Let me ask
okay.
you this. Let's talk about the term foreseeability. That's kind of a follow-up to Judge Palmer's question. But if it was foreseeable that you all would not be approved, who would bear the burden or who would bear the responsibility under the lease?
Well, the judge, I think, asked that question at the
All right,
hearing.
so I'm asking you.
Whereabouts? You're
I'm asking
me?
you, if it was foreseeable, would your client still be on the hook?
If it was foreseeable they wouldn't get it, they wouldn't have signed the lease unless they had approved
Well,
it.
that wasn't my question. If it was determined that it was foreseeable, would your clients be on the hook? If it was foreseeable that your clients would not be approved, would they have been on the hook based on the language of the lease?
I can answer that question, yes. The
Okay.
fact is, though, that it was not foreseeable.
Okay.
And that becomes the
We
critical
were
issue.
not allowed to present that. We were cut off, and this is a fine. I mean, I'm 50 years in the practice and I get a little plaque, so I've seen a little bit. But this is a very competent judge, but it was, bang, let's get this thing going. And I'm sorry, I was there, I can see that. But yes, it's right in the lease, it's our job, obviously. And we did what we could do. So, there we go. Now, the all's right is that the opponents never countered the affirmative defenses except by what we call naked argument. And naked argument doesn't do it. We don't like impossible, you know, you knew you couldn't get it. And the other thing that bothers me is I'm competent to do this, and then makes a statement of fact that we didn't move out till March, and that's part of the $200,000, when our affidavit shows we moved out in February. When we knew we couldn't do it, we're gone. So, again, I'm going to leave it there because I think the fireworks start with the opponents as to why I just don't think that this court or any court allows a summary judgment in either this amount, if it was $2 in this amount, based upon insufficient affidavits, no countering the affirmative defenses, and the case law on that is the Haven case, which has been followed by this court, and you just have to counter the affirmative defenses. You have to rebut them or show they're insufficient. Now, How can they do that? So, anyway, rebuttal will come. If you have any more questions, fine. I have about 9 minutes, I guess, or excuse me, 11 minutes for the
Yes, you do, sir.
rebuttal? Or no, Mr. Bounty does.
thank
Thank you,
you.
Your Honors, and sorry, I could not answer that question. Drop-in childcare, I'll have to go and find out what that means. I think it's drop-off.
Drop off, drop in. That may be drop off.
Good afternoon, Your Honors. May it please the Court, Megan Serrano for the appellee in this case, BRE Mariner Conway Crossing, for short, the landlord.
Do you agree that foreseeability is a critical issue in this case?
Foreseeability is absolutely the critical issue,
So
Your
if there
Honor.
was a disputed issue of fact as to whether or not it was foreseeable, this should not have been a summary judgment case. Do you agree with that?
That is correct. Not only was the license issue foreseeable, it was foreseen. It was addressed specifically in Section 5.01 of the lease, which is at page 110 of the record, where it states that Genuinely Loving Childcare is solely responsible for obtaining any and all license and permits which are required to operate its business, and that the landlord makes no representation whatsoever regarding tenants' ability to do so.
Yeah, but doesn't that provision mean that the party that's responsible for doing all the work to submit the applications, et cetera, is the tenant, not the landlord?
Correct.
I mean, that doesn't say that the tenant guarantees they'll be able to get it or takes full, burden if it doesn't happen.
I would argue that it does put that burden on the tenant, Your Honor, because...
Well, let me ask you this. If, for instance, the legislature, after the lease was signed, the legislature said, enacted a law that said daycare centers or childcare centers could not be placed in a mall, and that came out of the blue and no one expected it, would it be your position that based on that provision in the lease that your client still wins, or would that fall into the category of an unforeseeable risk?
That would probably fall within the category of something unforeseeable because thinking back to the provisions of the lease, I don't believe there's any provision in there regarding a change in the zoning law or something that would impact tenants' ability to operate a daycare center at the premises.
So if DCS policy had been to approve child care centers in this situation, and then all of a sudden they changed their policy, would that be foreseeable? And I'm not saying that's the facts. I think that's what they allege the facts were, but if those were the facts, would that be foreseeable?
That is certainly the position that they're taking, Your Honor, and they're taking the position by receiving the urban designation, which the landlord does not dispute that they obtained, that they necessarily would have obtained a license. That's not consistent with the Florida Administrative Code provisions regarding the urban designation. The site is section 65C-22.001 subsection 1E. And in that section, it makes clear that obtaining the urban designation is merely the first step to obtaining a license to operate a daycare center which does not have outdoor play space. There are many other approvals that are necessary in order to get that license. So in other words, it was not a sure thing that tenant would be able to obtain that license even though it had the urban designation.
If you recognize foreseeability as the critical issue here, what is it you contend was or was not foreseeable? What's the event that has to be foreseen in this case?
In this case, the tenants are taking the position that it was unforeseeable that DCF would not give them a permanent or non-provisional license. And it is our position that since tenant did not have such a license in hand, and indeed had not even filed an application for a license at the time it signed the lease, it assumed the risk that such a license would be denied when all it had was that initial predicate under the statute of the urban designation, again, which is only step one to obtaining the actual license itself.
Is there not a possibility that they could have presented some evidence on the issue of why it was or was not foreseeable, what representations were made to them, what the standard practices are, as opposed to, you've referenced the administrative code section, but that's just one piece of the puzzle, right? Could they not, in some circumstances, be able to show that it was not foreseeable? Let's say, for example, they had an absolute promise from somebody that they would get it, and then the agency changed its mind. Would that be a situation where they could show that it was unforeseeable because they had a lock-solid promise and then somebody changed it?
Again, that's the position that they're taking. The affidavits go into lengthy detail about conversations with people within the licensing unit at DCF. The landlord does not dispute any of these facts. However, the lease made clear that it was tenant's obligation to get the license.
So if they do not get the license, regardless of the reason why they don't get the license, the entire risk is on them.
Yes, and they are in violation of the lease.
And that would be in case, as Judge Evander said, the law was changed, the rules were changed. Doesn't matter.
Yes.
If the zoning laws were changed and said you absolutely can't have it there, that's foreseeable, and therefore they're on the hook for it, the landlord's not. Is that your position? That anything that would prevent them from operating there is foreseeable by them, and therefore they take the entire risk?
No, that's not the position, and certainly Your Honor is much more creative than I am in coming up with scenarios which would be unforeseeable. In this case, it's impossible to get around the fact that this circumstance, which the tenant has taken the position is what made it impossible for them to perform under the lease, was not only foreseeable, but was foreseen and was made an express provision of the lease. There are things which tenant could have done to mitigate its risk in this regard and mitigate its damages. I mentioned earlier that the application was not in fact submitted. The lease was signed prior to the application being submitted. And in one section of Ms. Rocchi's affidavit, she states that in order to submit the application, you need to include a lease with a term of at least a year. Well, this lease was entered for 5 years. Again, without a license in hand, one way to mitigate that risk could have been to have the lease be for a shorter period of time.
And they were actually allowed to operate for a year, correct?
Under the 2 provisional licenses they obtained, they were there for a year, yes. Another way that they could have mitigated this risk is to include a termination provision. Such things are very common in commercial leases, stating, for example, that the tenant would have to use its best efforts to get a license, and if after using its best efforts and exhausting all reasonable avenues it was unable to do so, then it could terminate the lease. It elected not to do so. What the tenant is what the appellants are trying to do here is they're asking the court to rewrite the lease because they don't like the bargain that they got, but this is the bargain that they struck. The court is constrained to apply the lease as written. The appellants
The lease doesn't say that if for whatever reason they do not get approval to operate a child care center, that the tenant still forfeits the lease and owes all monies owed under the lease. I mean, it says that they'll be responsible to obtain it, which is they do all the work to do it.
Correct.
So, you mentioned that the lease could say, that if they can't get it, they get out of the lease. But on the other hand, it could say that if for whatever reason they can't get it, they're still obligated to pay. But it didn't say that either.
No.
I mean, it just said that they're responsible for getting the permitting.
Right. So when they were unable to do so, they left the premises. They did not advise the landlord, even though the lease required them to do that. And as a result of their termination of the lease and their failure to make payment under the lease, they were in breach, and landlords sought the accelerated rent. I wanted to address one additional point that counsel brought up regarding the amount of damages in this case. Again, this was an early termination of a 5-year lease, so the $200,000 figure of damages represents all of that time still in the future for rent. The final judgment in this case included a provision stating that landlord could bring an action for an accounting in order to credit the judgment with any amounts it had recovered from another tenant who occupied the property. And this judge, the reply brief was very critical of the trial judge, which I think is very unwarranted. She was extremely thorough in this case. There are multiple places in the record where she encouraged the parties to come back if there was any dispute over the amounts that were owed. When counsel brought up a point regarding the license, she said, please file a motion for reconsideration if you think that's appropriate. So this trial court was nothing if not thorough, and the counsel's indictment of the trial court is unfair in this context.
Any questions? All right, thank you.
Thank you.
Thank you, Your Honors. May it please the Court. Just to quickly, my name is Shane Bowdy for the appellants. Just to quickly follow up, I think, on multiple questions that were asked, and I believe the Court certainly has a clear picture of the issues here, certainly of foreseeability. And there certainly could have been many provisions on both sides that could have been a little clearer in the lease. But on the issue of foreseeability, which is the crux of the matter here, it's certainly important to note that in the affidavit in opposition of the summary judgment motion, the appellant says that prior to signing the lease, they got the urban designation. Prior to signing the lease, they met with DCF and made sure that this was going to be an okay space, that they got the urban designation, and that they were prepared for indoor play space.
Does the lease, I'm trying to find, does the lease call for the licensing for the daycare center to be in hand at the time the lease is signed?
Does the application for DCF?
Does the lease itself say that, that the tenant has to have had approval, have a license in hand for operation of the daycare at the time the lease is signed?
No, not to my knowledge, it does
Okay.
not say that.
Wasn't it actually the opposite? Didn't you
Yes.
have to have a signed lease when you applied for the license? That was
Correct.
your
Okay,
requirement
that was
to
it.
get
I
the
had it
Correct, yeah,
backwards.
yeah. They had to have a lease. So they went and did their due diligence. They went and asked DCF, hey, this is the spot we're looking for. We want to make sure we can do indoor play space, because there certainly are concerns. It's a shopping center. Can we do this? And DCF, according to the affidavit presented, said, yes, this is urban, that's fine. So I think the issue, and we had some great questions there about what could have been in the lease, and the real issue is, why was the license, the permanent license, not granted? If the license wasn't granted because, let's say, somebody who had applied had a criminal background, something like that, that's a foreseeability issue I think would have been on the appellants. I think that's certainly true. I think the issue, though, is it was denied or not given them the full license because of the play space, which was an issue they had already addressed. So that's why it wasn't foreseeable that that issue would be the one thing preventing the permanent license. From that point, there certainly could be arguments made that, and it's in the record, of what happened after that. A lot of the briefs were after the effect, what happened afterwards when the provisional licenses expired, but it really is important on the foreseeability issue on what happened before they even entered the lease. And afterwards, all the rest of it with, whether or not the landlord could have done something to help keep them there, whether or not it was still appropriate for indoor or outdoor play space, what they could have done afterwards, I think is kind of irrelevant. I think foreseeability is certainly the issue, and for that reason, we would request that you remand this back. Thank you.
All right, thank you both.